Hey everybody, welcome to our refresher on the public records law and open meeting law. I'm very happy to have here Town Council Christopher Heap and Ivrea Freed, who will be making the presentation. They'll be doing about 40 minutes of presentation, and given the limits of this technological platform, we are going to have the questions at the end. So at the end, if you have specific questions, please just raise your hand and I will move you over the webinar and you can ask your question. So with that, Chris, I would turn it over to you, and welcome to Needham.
Thanks very much, Kate. Hello, everybody, and thanks for being in attendance tonight. As Kate mentioned, we've prepared a quick overview of the public records law and the open meeting law, and I'll jump right into it, but starting with the public records law. And before I do, I will just put up on screen PowerPoint presentation and jump into it from there. Okay, so first with the public records law, this slide is just meant to sort of show all of the various sources of law that have a bearing on public records in Massachusetts. The public records law is a little bit unusual in that Chapter 66, Section 10 is what we think of as most of the public records law. That section of the statute deals with filing requests for public records and the town's obligations in terms of a response to those requests. But the law also has a separate part, which appears all the way back in Chapter 4, Section 7 of the general laws, which is where we find the definition of public records and a number of exceptions to the definition of public records. So oftentimes when you're working with this law, you need to refer back to Chapter 4. In addition to both of those, the Secretary of the Commonwealth maintains regulations governing public records and also a public records law guide, which is published and available online. That guide is not short, but it is very helpful. It's a great resource and one that we refer to all the time when reviewing and responding to public records requests. So next, I want to turn to the definition of public record and the question of what is a public record for purposes of the public records law. And public record is defined incredibly broadly. In the statute, it's defined to mean all books, papers, maps, photographs, recorded tapes, financial statements, statistical tabulations, or other documentary materials or data, regardless of physical form or characteristics, made or received by any officer or employee of the town. So that's an incredibly broad definition. And it means that any document can be a public record, regardless of whether it is made or received by a town employee or official in a town email account, or on a personal one, and regardless of whether a document is made or received by a town official on a town computer or a personal one. The important part about a public record is really the substance, whether it concerns town business more so than where the document is made or received. So one important caveat to add to that is that any email or communication made or received on a town computer is likely to be a public record, regardless of whether it's concerning town business or if the substance is more personal. And any town business that's done over personal email or media or computers is going to be a public record as well. So any communications concerning town business, regardless of where it's created, is going to be considered a public record. Okay, now having just spoken for a moment about how broad the definition of public records is, I'm going to talk in a second about several exceptions to the definition of public record. These are documents that, although within the town's possession, would not need to be disclosed upon request from a member of the public. But before I start talking about the exceptions to the public records law, I just want to pause for a moment and note that the presumption always is that a record is going to be public, unless it complies with specific requirements of one of the listed exemptions in the statute. Okay, so what are the exceptions to the public records law? The public records law has 22 different listed exceptions to the definition of public record. And not many of those are going to be particularly relevant to to any number of the boards and committees that are represented here tonight or watching online. So I don't want to go through the entire list of 22, but I guess I do want to jump through a couple of representative examples of what falls under the exceptions to the public records law. The first of these, and these are sort of the most important and the ones we most commonly encounter when responding to a public records request. The first one is things that are specifically accepted from disclosure by some other statute in the general laws other than the public records law. Outside of the public records law or chapter 4, there are a number of other examples in the statutes where towns or state government are instructed not to provide information upon request. Some examples of these are Chapter 71, Section 34D, which protects student records, CORI information, and statutes providing for confidentiality of domestic violence records. So those are some examples of statutory exceptions that we need to consider if they're covered by a particular public records request. Another exception that we commonly see under the public records law is privacy. And the specific exception here in the definition of public records is personnel or medical files or information and any other materials or data relating to a specifically named individual, the disclosure of which may constitute an unwarranted invasion of personal privacy. If a document falls into that category, that would not be something that would need to be disclosed upon request. Exemption D of the public records law covers the deliberative process. And this is an exception that covers policy positions being developed by town boards and officials as they are underway. This specifically covers interagency or intra-agency memoranda or letters relating to policy positions being developed by the agency. And again, that exemption only really applies as long as the policy position is in the process of being developed and no longer after it's been completed. Exemption N to the public records law covers security information, particularly regarding the deployment of security measures for town functions. Exemption O covers personal information relating to appointed officials only, home address and phone number and other personal information for appointed officials. And the last one I'll mention here is attorney-client communications. Any communications between the town or town officials and its attorney are covered by the attorney-client privilege and would not be subject to disclosure. That exemption does not actually appear anywhere in the public records law or elsewhere in the general laws, but in 2007, in the case of Suffolk Construction Company, the Supreme Judicial Court did rule that attorney-client communications, even though they may technically be considered public records, do not need to be disclosed upon request. And as I noted, that is just 6 out of 22 exemptions noted in the law. So there are plenty more that I think time doesn't really allow for us to cover here. So the point I'll leave you with on this slide is if there's ever any question about whether something is covered by an exemption, just ask and we can discuss it. Okay, so that's the definition of what is and is not a public record. Now I want to speak a little bit to public record requests and how the town responds to them. This is, at this point, I think the bulk of the municipal work in terms of complying with the public records law is receiving and responding to public records requests from members of the public. The point I'd like to make here at the outset is that there's no minimum required level of formality when someone makes a public records request. We often see detailed letters from council asking for documents, and we often also see 2-sentence emails from members of the public. Both constitute a public records request and both would need to be responded to. there is no particular form or format that the town can require before it initiates, undertakes the exercise of responding to a public records request. So I guess if there's ever any question about a communication that's been received, does or does not constitute a public records request that needs to be responded to, our recommendation is always to contact the records access officer in town, which is the town clerk by default, but I believe there are others in town as well. Okay, so once we've determined that we have a public records request, now it's time to discuss how to respond. And the most important point here is that once a request is received, the town has 10 business days to make a response to the requesting party. And that response can come in a number of different forms. There's no one right way to respond. The town can simply provide responsive records. The town can respond that there are no responsive records. And now after that, on this list, we get into a little bit more complicated forms of response, which I'll speak to in some more detail as we go through the slideshow. The town can withhold records if they are subject to one or more of the exemptions provided in the statute, a couple of which we talked about a moment ago. The town can the town can claim additional time to respond to a request if it's warranted. The town can also ask the requesting party to modify their request, clarify their request, or submit an estimate to the requesting party of the fees that the town is going to charge in order to produce the response. Several of these types of responses, they all require written responses, and several of these also require the town to notify the requesting party that they have a right to appeal, and then that party can take an appeal if they so choose. Okay, so going through that list in a little bit more detail, that's the types of responses we can provide to a requesting party. First on the list was provide responsive documents. That's easy enough. If the request is one that the town can respond to within those 10 days, the town is obligated to provide the document, and the documents are not subject to an exemption. The town is required to provide those documents within those 10 days. The town, if there are no responsive records, the town can notify the requesting party of that. That needs to be in writing. So you need to send a letter saying there are no responsive records. And just one additional sort of practice point that we like to note here is that the town can simply say, we don't have any responsive documents, or the town can also provide some additional explanation as to either why there are no responsive documents or where a party might find some helpful information that they were actually looking for. For example, if a request asks for all emails between certain board members about a particular matter, the response might note that there are no such responsive emails, but direct the requesting party to the minutes of a meeting where that matter was discussed. That's not legally necessary, but in some cases it can provide some additional information and perhaps head off another request from the party looking for that information. And the only other point here is that when responding to a public records request, it's helpful to be quite literal and confine the response to what's been asked for. So if someone's asked for emails, the town is under no obligation to provide minutes unless it thinks it might be helpful. So that's just, the response should be tailored to the specific nature of the request that was submitted. As noted, also on the list of potential types of responses to a public records request, the town can withhold a responsive record if it is subject to one or more of the exemptions that we discussed, or the attorney-client privilege. But there are some specific requirements that we need to adhere to when doing this type of response. The letter in response, if we're withholding records, must describe the documents being withheld, cite to the specific exemption that's being claimed, and explain how that exemption applies to the documents. In some cases, if a document is subject to the attorney-client privilege, it may also be necessary to provide a log of the communications that are being withheld. This type of response also needs to note that the requesting party has a right to appeal our response to the supervisor of public records or to Superior Court. Another type of response that we can send if needed is the town needs additional time in order to provide a response. The particular and as noted, the baseline response time is 10 business days from receipt of the request. But the town is permitted to claim additional time. And the standard for doing so is because the magnitude or difficulty of the request or the multiple requests from the same requester unduly burdens the other responsibilities of the town. If that is so, the town can send a letter unilaterally claiming additional time to provide the response, provided that the additional time cannot add up to more than 25 business days from the original receipt of the request. Okay. Now, another form of response that we can send to someone requesting public records is a request that they modify or clarify the request. The standard for doing this is to enable the town to produce the records more efficiently and affordably. In our experience, this type of response can be incredibly helpful both to the town and to the party requesting the documents, who in many cases, a request that they modify or clarify their request can result in substantially lower fees that are charged in terms of the town's production of the response. So it can be helpful to both parties on that front. So in our experience, this is probably the most useful first step when the town is presented with a complicated or request, or one that's going to require them to produce a lot of documents. Also, this request to modify or to clarify a public records request has the effect of stopping the clock for a response. So if the town sends this out, it can then wait for the requesting party to either agree to modify or clarify their request or not. But in any event, the town's 10 business day deadline for responding is told while we're waiting for a response there.
Chris, just to add to that, if the requester does in fact modify their request, then the clock restarts and the town has an additional 10 days from the date that the town has received the modified request. So it tolls it, but also will restart it in the case that the modification is made.
Great, thank you. And this slide just shows an example of sometimes people submit requests that are intentionally broad, and sometimes people submit requests that are perhaps unintentionally broad. And a response of this type can sometimes have the helpful effect of revising the response to one that is easier for the town to respond to and more narrowly targeted to the documents that the requester is actually looking for. When submitting this kind of request, it is also probably helpful to include a preliminary fee estimate for the possibly overbroad public records request to show to the requesting party what the broad original request might result in terms of fees. So next up is the options available to the town in terms of charging fees, either unilaterally on its own motion, or seeking permission from the supervisor of public records at the state level to charge fees. The first form of response here is a fee estimate, and that's the one that the town can send as the initial response all on its own. And a fee estimate is one that the town can send for to charge for the following things. The town can charge for searching for documents, segregating or redacting documents as required by law, and segregating or redacting attorney-client communications. We can do this on our own, and we need only send the requesting party an estimate of what it's going to cost the town to do all of the one or more of those three items. Sending that fee estimate also has the effect of stopping the clock on the 10 business day response time, and the town can wait until the requesting party either agrees to pay the estimated fees or declines to do so, in which case no further response is required. Now, there's another approach that the town can pursue, which is to seek permission from the supervisor of public records to charge fees. There are certain categories of fees that the town does need permission to charge for, and those are redactions or segregating of documents that are not required by law. And those are some of the exemptions that we discussed before. There are also cases where a particular public records request might look for documents that we have to withhold or redact, and others that are optional withholdings or redactions. And in those cases, we would also need to seek the permission of the supervisor of public records. This is just a quick slide on how a fee is calculated under the public records law. The town is obligated to not charge for the first 2 hours of work needed that are devoted to responding to a public records request. The town can only charge up to $25 when responding to a public records request, or the lowest paid person who is capable of performing that task, whichever is lower. And the town can also charge $5 per page for copies and the actual cost of producing the response. And as I noted earlier, the sending an estimate stops the clock for responding. And at that point, it's incumbent upon the town to wait until a response from the requesting party to see if the town is going to move forward. Well, if the party is going to move forward with the request in light of the fees that we've estimated the town is going to incur in providing that response. Now, this is the other form of charging fees, and this is the petition, the one where the town needs to seek the permission of the supervisor of public records. This is necessary, as I said, for cases where we're going to charge for redactions that we're not obligated by law to provide, but might nonetheless be optional or called for in certain cases. The town can petition the supervisor for permission to charge over $25 per hour, but needs to obtain permission to do that. And that might happen in cases where the staff or official or counsel who are going to be necessarily be tasked with preparing the response are going to result in costs to the town above that $25 per hour. The town can also request relief from responding to a public records request from the supervisor in cases where requests have become overly duplicative or harassing. And the town can also request additional time beyond the 25 days. And I believe that the maximum there is 30 additional business days beyond the 25 that the town can claim for itself.
Chris,
yeah.
I think it might make sense to just pause and explain the difference about which exemptions are discretionary and which exemptions are required by law. So as Chris was saying earlier, Exemption A allows the town to redact records where other statutory schemes require those redactions. So for example, if a Corey document, a document that the police department has that discusses an arrest, there's another statute, the Corey statutes, that preclude the town from releasing that document. So that's, in the eyes of the supervisor of public records, a redaction that is required by law. All the other exemptions that Chris went through, and actually all of the 21 other exemptions, are discretionary. So Exemption O allows the town to withhold an appointed employee's personal phone number, but the town can choose to release that number if it wants. That's a discretionary exemption. And so in the eyes of the supervisor of public records, they view that as a redaction that is not required by law. So basically, the difference here is that if you're going to be reviewing documents and redacting documents for any of the exemptions other than Exemption A, you need permission from the supervisor to charge fees. And this is a change that occurred in the law in 2017. So many people may be familiar with just providing fee estimates all the time, but when the law was revised, that ended. And now we have to basically always ask permission from the supervisor unless there's some other statutory scheme that requires the redaction. And so this kind of ties back into the 10-day window. You know, there's a lot that needs to happen before the 10 days. And one of those things is getting the fee petition out if you want to charge fees. So it's important to quickly perform an analysis of what records may be responsive, whether you think you need to charge fees, to review those records, and then reach out to your RAO if you think you need to petition the supervisor to charge. So I just wanted to make sure we all understood the difference between bylaw and discretionary.
Thank you, that's great. One last note, if we do a fee petition to the supervisor and a response is not going to be forthcoming within the 10 business day window, we still need to send the requesting party a separate written document saying that we're waiting for that response. So a response always must go to the requesting party within the 10 business days, even if we're waiting for word back from the secretary, from the supervisor of public records. So this slide is just meant to be a sort of flow chart of our thinking when we're reviewing a public records request. I don't necessarily need to go over it again now. It's, I think, intended to be maybe more helpful for reference later on as everybody's responding to public records requests in the ordinary course. This flow chart is mostly just intended to suggest that once a request is received, it's either going to be easy enough to produce the records, or we're not going to have the records. We may want to do a fee estimate, or if the request is complicated enough that it doesn't fall into those categories, it's often going to be the best first step to request a modification. And then we can move on to the next part of the flow chart if, depending upon how the requesting party reacts to that request to modify their public records request. A couple things to note about responding to public records, and this goes to how we provide the documents in our response. When we're providing records, we must provide the public records by electronic means unless the record is not available in electronic form, or the requester does not have the ability to access public records in a usable electronic form. If the requester indicates a preferred format for the documents, we must provide the documents in that preferred format to the extent it's feasible for the town to do so. And finally, when responding to a public record request, it may be useful to ask the question about whether or not the documents are ones that might be posted on the town's website. Because as a separate component of the public records law, there is a requirement that the town must post commonly available public record documents on a website maintained by the town to the extent feasible. And this is a list here of what are considered commonly available public records that should normally be posted on the town's website to the extent it's feasible for the town to do so. Appeals, as noted, in most of the types of response to public records that we're going to provide to requesting parties, we will note that there is a right of appeal either to the supervisor of public records or directly to Superior Court. And that's a choice that the requesting party gets to make all on their own. The recent changes to the public records law added for the first time, I believe, a possibility that a requesting party, if they take an appeal, might potentially recover fees from the town if they're found to be correct on appeal. So that's just I only add that to note the importance of framing these responses when we first make them and reviewing them closely to make sure that our response complies with the law. Identity of the requester. This is I think a point that is not frequently important, but when it is, it can be very important. So we wanted to include this in the presentation just to plant this idea. Under the public records law, the identity of the requester cannot be considered. The public records guide instructs that under the public records law, every requester is treated equally. Therefore, even a person who is the subject of the record is not granted any greater access right than any other person. Access to a record requested pursuant to the public records law rests on the content of the record. So the main point here is that if a document is properly withheld or redacted, if it was requested by a random member of the public, it should still be withheld or redacted, even if the subject of the document asks for it, or let's say their parents or their relatives or their family. It's important to identify information that ought to be withheld or redacted and do that in all cases. And the final point on the public records law, before we move on to the open meeting law, it regards records retention. The public records law requires that the town maintain public records for different, depending upon the category of the document, for different periods of time and go through different processes for destroying them after that time is up. The state maintains a detailed municipal records retention schedule, which governs how we do this. So point number one in terms of retention is do not destroy public records without reference to the retention schedule. And point number two is that complying with records retention is made much more difficult when town officials, board members, staff, et cetera, create public records in personal email accounts and on personal devices. So the need to comply with the records retention schedule is just another reason to avoid doing that, if at all possible. All right, now a relatively brief walk through the open meeting law for those of you who maybe aren't familiar with all the provisions or need a quick refresher. Begins at this slide right here. So the open meeting law, in a nutshell, requires that all meetings of a public body occur in a posted meeting held in open session, and it contains a number of other requirements for how these meetings must be conducted. So the first question here is, what is a public body? The definition of public body in the open meeting law is incredibly broad and should be assumed to cover all boards in town, whatever they're called and however they were created. The actual definition of public body covers a multiple member board, commission, committee, or subcommittee within any town, however created, elected, appointed, or otherwise constituted, established to serve a public purpose. And the definition then goes on after I skip a little bit to say that a subcommittee shall include any multiple member body created to advise or make recommendations to a public body. Now, we often recently field questions about whether subcommittees or working groups must adhere to the open meeting law, and the general response based on that broad definition I just noted is yes. Subcommittees and working groups are generally subject to the open meeting law. And by way of quick example, a 5-member planning board is a public body, clearly under the definition. If the planning board were to task 2 members to study a particular area for rezoning or think about a particular project and come back after doing that and report back to the whole board, those 2 members, even though less than a quorum of the 5-member board, are a subcommittee and would need to comply with the open meeting law when communicating with each other. Next is, what is a meeting? And the open meeting law defines meeting as a deliberation by a quorum of a public body with respect to any matter within the body's jurisdiction, with certain express exemptions. Those exemptions are as follows. These things are not considered meetings. On-site inspections, and here we think of site views by permitting boards or other boards going off to look at a project off-site. Those are not considered public meetings. Outside events such as conferences, trainings, or social events, or another board's meetings. So if the planning board attends a select board meeting, that is not a meeting of the planning board. But all of those 3 things I just cited are subject to the caveat that there cannot be any deliberation among the board members, or else it does become a meeting. So board members can go out to a site visit, look around, but they cannot discuss the project or the application before them. And in my other example, the planning board can attend a select board meeting, but if they start talking amongst themselves as a board about something within their jurisdiction, then it does become a meeting. And that becomes a violation of the open meeting law, absent an agenda being posted and other measures to comply with the open meeting law. The final exception to the definition of meeting in the statute is town meeting. Town meeting is not, board members in attendance at town meeting are not engaging in a meeting for purposes of the open meeting law. Finally, in terms of the ingredients of a meeting under the open meeting law we need to have a deliberation. So what is a deliberation? It's an oral or written communication through any medium, including email, between or among a quorum of a public body on any matter within its jurisdiction. Therefore, based on that definition, emails among a quorum of a board or a meeting, text messages between a quorum of a board can constitute a meeting, Facebook comments can be a meeting, phone calls can be a meeting, as long as they involve a quorum of the board. Which is why board members generally must refrain from communicating with one another outside of a publicly posted meeting. Now, so as always, there are a couple exceptions to the definition of deliberation, and those are these. Less than a quorum of the board can communicate with one another without creating a meeting under the open meeting law. So 2 members can generally speak. That is not so, however, if those 2 members constitute a subcommittee that has been created or tasked with performing a particular mission. And it's also not true if 2 members or less than a quorum of the board members communicate, but then serially bring in other members into the communication. So if there's a 5-member board and 2 members are speaking to one another, that can be permissible under the open meeting law. But if 2 members discuss something and then one of those 2 members goes off and discusses the same thing with a 3rd member, that has created a violation of the open meeting law, even if all 3 were never communicating at the exact same time. Other exceptions to the definition of deliberation are distribution of meeting agendas, scheduling, or other procedural communications between the board, as long as no opinions are being expressed. It is okay to sometimes engage in scheduling or procedural things like that without violating the open meeting law. Okay, so that's the definition of a meeting and some of what we need to avoid in order to avoid violating the open meeting law. Here are a couple quickly. I will go through this very quickly, but some procedural requirements in order for a board to meet in a properly noticed meeting. An agenda, in order to conduct a meeting, an agenda must be posted, and it must be posted at least 48 hours ahead of the meeting, excluding weekends and excluding holidays as well. The agenda needs to note the location and the time of the meeting, advise members of the public what is going to be discussed. So that's why we list on agendas individual matters that are going to come before the board. And if executive session is the only topic, it must note an open session on the agenda before the executive session. Agendas for meetings need to be posted both in town hall and published on the town's website. So that's the agenda requirement. The open meeting law also contains detailed discussions of what needs to be included in the minutes of a meeting. And those are identified, those basic components of the minutes are identified here. They need to note who was present, recite all of the votes that were taken, and they do not need to constitute a transcript of the meetings, but they do need to include sufficient detail that somebody could understand what was discussed. The open meeting law requires that all minutes of a meeting be approved by the board within 30 days of a meeting or within the next 3 regular meetings, whichever comes later. And this is just a quick note about the differences between the one difference between the open meeting law and the public records law, which is that under the open meeting law, if somebody requests minutes or draft minutes, they must be provided to the requesting party within 10 calendar days of a request. Whereas as we discussed before, under the public records law, for any other type of public document, the town has 10 business days to respond. Now, one of the hot topics under the open meeting law recently is remote participation. And I think anybody involved in town government over the past year has almost certainly become well familiar with the fully remote Zoom meetings that have been happening throughout the pandemic. The ability to conduct those meetings remotely over Zoom was set to expire in June, along with the lifting of the state of emergency, but it was just recently extended. Chapter 20 of the Acts of 21 extended the time to conduct fully remote Zoom meetings through April 1st of 2022. That's one kind of fully remote participation that is allowed under the open meeting law. And I just wanted to note one other type that's a little bit different. The open meeting law does allow for individual members to participate remotely in a public meeting where the remainder of the board is physically present. And that is allowed for in certain limited circumstances where physical attendance by the remote member is going to be unreasonably difficult. A quorum and a chair is physically present at the actual meeting site. The chair announces the name of the remote participant. Everybody can clearly hear each other. And the last requirement here is that all votes are taken by roll call. Now that that type of remote participation is one that can only be conducted if authorized by the select board. And I believe that this has been authorized in Needham through the end of the summer. Okay, last thing I want to cover is executive sessions, which are meetings allowed for under the open meeting law, but ones that are not open to the public. And there are two important things to think about when considering going into executive session. The first is following the proper procedure for going into executive session. It's crucial to follow the proper procedure in order to preserve the protections of doing an executive session. And the second is identifying a proper purpose for going into executive session. The procedures for going into executive session are the board must convene in an open session. There must be a motion to go into executive session, identifying where non-members are invited into the meeting. The chair makes a declaration in some cases that certain conditions exist. For example, if the board is going into executive session to discuss litigation, the chair must make a declaration that conducting the discussion in open session would have a detrimental impact on the board's litigating position. And finally, the board must specify whether it's going to return to open session for reasons of, for returning to its meeting and conducting other business. And it must declare that one way or the other. And then all the votes to go into executive session, all votes taken in the executive session, and the motion to come out of executive session all must be done by roll call. So that's the procedure for going in. And there are 10 and only 10 specific statutory reasons for which a board may go into executive session. I don't want to go through all of those tonight. As I said, some of the more common ones that we see are boards are allowed to go into executive session to engage in collective bargaining, where conducting discussions in open session will have a detrimental impact on the board's bargaining position. The board is allowed to go into executive session to discuss litigation, where doing so in open session might affect the litigating position. And there are a number of others specifically listed in the open meeting law. I will say that those are listed in 38 section 21, and we also have available for sharing with anybody who is interested a 2-page effectively cheat sheet that lists the procedure for going into executive session, includes a model motion for doing it, and on the back contains all 10 specific reasons for going in. So we can circulate that or make that available to any board or committee who wants to have that available to them at their actual meetings. And finally, last slide, I believe, is upon receipt of a complaint that a board or a committee has violated the open meeting law, that board or committee is going to have to meet to discuss it and produce the complaining party with a written response within 14 business days of receipt. So it's incumbent upon everybody, if to the extent there's ever a complaint, to meet almost immediately and produce a response to that. And that is our quick overview of the open meeting law as well. That's all we have by way of our prepared comments, but we're happy to stick around and answer any questions people have for as long as they have them.
Thank you, Chris. If you could stop sharing, and anybody who has questions could use the raise hand feature. Give people a second to raise their hands.
Sure.
That was very informative and very quick. I'll make sure we get that cheat sheet available to people who want it. I know I have that. Get that up for you. I know the question of subcommittees and working groups comes up a lot, so I really appreciate you handling that one. I would note, maybe I could ask Chris, I believe it's true that the board, say you have a board of 5 and they have a staff person, all 5 can talk to the staff person. Could you talk a little bit about that?
Avery, do you want to handle that
one? Sure. So under the open meeting law, all 5 members could talk to a staff person about the same matter. However, you have to be cautious that you don't engage in serial communications, and that's utilizing a third party, typically a staff person, someone that's not a member of the board, to convey your thoughts to other board members. So for example, if a member of the ConsCom speaks to the ConsCom agent and says, I think we should issue the order of conditions. And then another person talks to the agent and the agent says, person 1 thinks we should issue the order. And then person 2 says, well, I think we should issue it, but with this condition. And the staff person goes back to the first person. So you have to be really cautious when you use staff, but they are a great resource. And there is something called the aggregating decision. And this is a Bolin decision from an appeals court in 2018. And in that decision, they said that what you can do is all members of a public body can send their comments on a document to a staff person, and the staff person can aggregate those comments into one document. But if that staff member wants to recirculate that document back to the board members, they have to do one of 2 things. They can either do it at an open meeting, or they can send the document back to all the board members, provided they also make the document available to the public by posting it online and providing a copy to the town clerk. And the reason that the court thought that this was okay was because what they were saying was essentially that compiled document contains the thoughts and opinions of all the board members. So if any member reads that document, they will essentially be having a deliberation, even though they're not, technically saying anything to each other. They're reading the thoughts of another board member. So staff can be useful in some ways. I think when we talk about the open meeting law, we often say that the legislature thought about transparency and then they thought about government efficiency, and they really weighed heavily on the side of transparency. So especially for volunteer members, you might be used to doing something differently in a business setting, and that's just not permitted under the open meeting law. And unfortunately, it slows down our workflow.
One thing I might add on the public records is for board and committee members who don't have town email addresses, if they copy a staff person on email that they send, that the town's email server will capture all of that information. And because you do have situations where board members are searching their private email for something they might have sent on government business because that's their tradition. So anyone who copies their staff member, it's going to get caught up in our archive system and they won't have to be produced. So it's a convenience to the board committee.
And I think one thing to add to that, Kate, is if a board member does not have a town email address, we might encourage that they create a new email address, you know, ivriafreed.conscom@gmail.com, and then have all of your town business through that email so that it's easy to search for records if a request is made. And in addition, as Chris was saying, there's all these retention requirements. So this, you know, a board member could leave and no longer be part of the board, but we may be reaching out to them in a couple of years asking for records. So it's important to kind of keep your stuff segregated.
And Kate, your question reminded me of one thing that I didn't mention about subcommittees, and that is that staff are allowed to convene groups that they've selected on their own to help them make decisions on matters that are within their independent authority. So if there was a question that needed answering that required you to you know, seek the input of the fire chief, the police chief, planning board member, and a select board member, but it was your decision and your decision only, the meeting of those five, I think 5 people, would not be subject to the open meeting law. But that exception is a really limited one, and it goes out the window if a group is being created by a board or a committee.
Okay, great. We are exploring options for expanding the use of town email and for guidance on the kinds of things that you mentioned, Ivria, and for copying staff. It's best practices, so we'll be working on that. I don't see any other hands, so we'll give it one last opportunity to ask questions. We will be sharing this recording and therefore the slides. If it's easier for people to get the slides, maybe we could share those out too,
sure,
rather than watching. I think it's a great resource, and on behalf of the town, I thank you very much, Chris and Evia, for joining us and providing this information. Thanks so much.
Anytime, thank you.
Okay. Bye, everyone.